Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Leonard Russo 361913. Today is Tuesday, December 3rd, 2024. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Corrigan Correctional Institution. Please state your full name and DOC inmate number for the record.
Leonard Russo 361913.
This is a public hearing. Public access to this hearing is available via video live stream. As you indicated, you would like to waive this hearing today. But prior to me accepting your waiver, I do have to inform you of the rights that you are waiving. So you are waiving the right to be represented by an attorney at this hearing. You are waiving the right to receive written notice of charges of violation. You are waiving the right to review the evidence against you before this hearing. You are waiving the right to receive to submit evidence in support of your case. And you are also waiving your right to call and examine voluntary witnesses and to cross-examine adverse witnesses. You're also waiving your right to speak on your behalf in regards to these charges. Do you understand these rights?
Yes, ma'am.
Okay, well, I accept your waiver and this concludes your revocation hearing. But please be informed that even though you're waiving your right to be heard on this case, I still have to review your case and make findings regarding the charges. But you'll receive all of that in writing.
Okay.
Okay, thank you. You're all set.
Thank you. Bye. Have a nice day.
You as well.
Good morning, P.O. Saunders. I'm still trying to call P.O. Esposito, just so you're aware.
Okay, I've sent her an email as well. Just to tell her we're ready.
Hey guys, Cody will be down here very shortly.
Thank you.
No, you're very welcome.
Good morning, officer. You would have to press *4, I believe, to unmute. You're unmuted. Can you hear me?
Yes, I can.
Okay, thank you. We'll get started as soon as Mr. Cote arrives.
Okay.
Full of people scan. Emails in the window tab. It'll be locked to the part. Good morning.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Eric Cote 431-646. Today is Tuesday, December 3rd, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Corrigan Correctional Institution. Please state your full name and DOC inmate number for the record.
It's Eric Cody, 431-646.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Public Defender Robert Famiglietti of the Parole Revocation Unit. Good morning, sir.
As well as your parole officer, P.O. Esposito.
Yes, Parole Officer Esposito, Norwich District Office.
This is a preliminary hearing which has three purposes under Connecticut law. To determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything that you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Cody, an officer, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. The state will have an opportunity to address the issue of probable cause. Once the state is finished, your attorney will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notes of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Officer, starting with charge 1, obey all laws, you may begin.
On 10/1/24, you were arrested by Brookfield, Massachusetts Police Department after you physically assaulted your girlfriend by punching her with your hands multiple times in the head and face. You are in violation of Connecticut condition, obey all laws. You are also in violation of Georgia condition number 2, law immediate notification searches. I will not violate the law of any governmental unit. I will notify my community supervision officer if I am arrested for any offense. My community supervision officer or any other community supervision officer may at any time conduct a warrantless search of my person, papers, and place of residence, automobile, or any other property under my control. You are arrested and Charge number 2, you were
Yeah,
arrested
travel.
in Brook.
Go ahead, sorry, I just wanted to state the charge.
Okay, charge number 2, travel. You were arrested in Brookfield, Massachusetts Police Department. You were out of the state of Connecticut at the time of this arrest, and you did not have permission to be in the state of Massachusetts. You are in violation of Connecticut condition travel. You are in violation of Georgia condition number 4, leaving state and absconding. I will not leave my state of residence, even briefly, or change my residence without first getting permission from my community supervision officer. I will not abscond from parole supervision. Charge number 3.
Reporting, yeah, charge 3, reporting.
Yes, reporting. You were released from Worcester House of Corrections on 11/12/24. You were required to report to the Connecticut Parole. Upon your release, you failed to report as directed. You are in violation of Connecticut condition release direction.
The state has also filed the following exhibits, starting with Exhibit A.
Connecticut signed conditions. Exhibit B is Georgia signed conditions. Exhibit C, there should be a correction to that. It should be Brookfield Police Department arrest narrative 24 BRK 53 AR, not East Brookfield Police Department. Exhibit D would be remand to custody. Exhibit E is interstate parole violation notice. Exhibit F, interstate parole violation report, and Exhibit G is the letter from the fugitive unit.
Counsel, did you receive the notice of parole violation report, and the other documents that were just marked for identification purposes?
Yes, I have.
Today, we have no witnesses, and at this time, the state will have an opportunity to make a short statement and testify with respect to probable cause. Officer?
Okay, so at the time of this violation, Mr. Cody was out of state without permission. He did not ask permission to leave the state of Connecticut to travel to the state of Massachusetts. He was arrested by, again, let me clarify, Brookfield Police Department, not East Brookfield Police Department, as in the evidence. As he at the time of that arrest, it was reported also that he was intoxicated, and when he woke up, he physically assaulted his girlfriend by punching her multiple times. The failing to report, he had been mailed a letter to the jail, which is Exhibit G, notifying him that he needed to report immediately. Even if it was after hours, he needed to call the answering service at the answering service number that was provided to him in the letter, which he did sign and date on October 23rd of 2024. And he failed to call or report as directed at that time. And that is it.
Thank you.
Thank you.
Counsel, it is now your opportunity to make a short statement and testify with respect to probable cause.
Well, my client contends his innocence and doesn't wish to offer any evidence here on the record as to what may or may not have happened in the state of Massachusetts. We don't have any comment as to probable cause at this time, only as to the release direction, failure report to Connecticut. We just contend that he may not have had notice.
And officer, would you like to offer any further information prior to me making my findings?
No, I think I stated already in my statement as to him not knowing that he needed to report. He did sign the letter from Worcester House that was sent to Worcester House of Corrections from the fugitive unit. He signed and dated it, so he was aware that he needed to report.
Thank you. Counsel, anything further?
Not as to the probable cause standard, no. And I have no comment as to the seriousness of the allegations. I mean, I would argue that they're not serious enough to hold him. He is still presumed innocent of the allegations. Thank you.
Thank you. An officer, or just so you guys are aware, this is a interstate case, so the Connecticut, the revocation proceedings will not happen by the state of Connecticut, so I'm not making a decision regarding the severity, only regards to probable cause.
Fine.
Okay.
So nothing further on both ends for counsel as well as the officer?
I have no comment as to probable cause.
No, not at this time.
Okay, thank you. I'm just gonna take a moment before I announce my findings. On charge one, obedience to the law, I make a finding of probable cause based on state's exhibits A, B, C, and F. On charge two, travel, I make a finding of probable cause based on state's exhibits A, B, C, and F. On charge three, reporting, I make a finding of probable cause based on state's exhibits A, B, F, and G. Being that this is an interstate case and coming from Georgia, revocation proceedings will not be conducted by Connecticut. The final decision regarding a revocation will be determined by Georgia and the interstate unit. Therefore, this does conclude the preliminary hearing for our purposes.
May I just say something to my client?
Yes.
Okay, sir, I contacted your attorney in Massachusetts, as well as the district attorney's office in Massachusetts, because obviously you weren't brought to court last Monday, and I wanted them to make sure that it wasn't a voluntary failure to appear. Okay? There still may be a bench warrant out of Massachusetts because your attorney that I spoke with said that it's not their practice just upon information like that to withdraw the warrant. What's going to happen now is that Connecticut Parole will notify Georgia to see what they'd like to do. And then if Georgia won't come and take you, they'll notify Massachusetts, I believe. Okay? When I find out more, I will let you know. Do you have your attorney's telephone number?
I don't.
Do you have a piece of paper and a pencil?
I have a paper. I don't have a pencil.
Okay, I will contact you by phone if he hasn't already with his telephone number.
Yeah, okay.
Take care, sir. Thank you.
Thank you. You're all set.
All right.
Thank
Thank
you.
you, Madam Hearing Examiner.
Good morning.
Hi, good morning. How are you?
Good. We have Mr. Acosta and Mr. Lopez today.
Yes. Which one would you like first?
Are they both there?
They are here.
Okay, we can start with Acosta.
Okay.
Thank you.
You're welcome. Acosta? All right. If you're gonna start in a few minutes, but I'll have you on for now.
Good morning.
Good morning, Mr. Acosta.
How you doing?
Good. We're not going to get started probably for another 5 minutes. We have to wait till 9:45.
Okay,
Thank you.
you're welcome.
Morning, my name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Louis Acosta, 232840. Today is Tuesday, December 3rd, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
Louis Acosta, 232840.
This is a public hearing. Public access to this hearing is available via video live stream. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. The testimony at today's hearing will be taken under oath. Mr. Acosta, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
Thank you.
You're welcome.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing or proceed without?
Proceed without.
You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
Thank you. Upon review of the documents submitted, the state's Exhibit K, remand to actual custody order, was not dated by the facility staff. Therefore, this hearing examiner is unable to establish when the remand of actual custody order was lodged. Without knowing when such document is lodged, I am unable to determine if you are afforded due process. Therefore, I have to your parole is reinstated today. Please keep in mind you're on special parole supervision until May 10th, 2025, okay? So being that your parole is being reinstated today, I do need to know what your release plan is for today.
I have a job with my brother.
Regarding where you're going to be, where you're going to live. Do you have a house like a sponsor or?
No, I have my fiance, 466 Franklin Avenue, Hartford, Connecticut, 06114.
466 Franklin Avenue. Is,
466, the third floor.
Third floor?
Yes, ma'am.
Okay. And what, I think I have the information here. I think she submitted a letter. I just want to make sure I have the proper information.
Yeah, she submitted a letter and an email, I believe.
Yep. So her name is Marilyn
Bermudez, yes.
Yep. And her phone number is, I just want to confirm.
407-701. I'm so nervous right now.
I have it here. Yep. So now, being that you're being released today, I don't know if if parole is going to have enough time to conduct a home investigation and do all of that. So you may have to go to a halfway house for today.
Okay.
But again, that's not up to me. I just want to make sure you're aware. So what area of a halfway house would you want to be placed in? Hartford or?
Hartford.
Okay.
Yeah.
Okay. So I'm going to notify DOC that your parole is being reinstated today. And so this concludes your revocation hearing, and I'm going to just direct you to DOC for further instruction, as well as your parole officer. They're going to be notified as soon as you walk out the door.
Thank you so much.
Okay, you're all set.
Thank you.
But please keep in mind, you're still on special parole supervision.
I know.
So you still have your parole conditions, you still have to report, and you're on parole, you special parole until May 10th, 2025, because you still have that standard time to make up.
Yeah. Okay.
Okay? All right, thank you.
Thank you.
Yes. I need to get right. Go home today.
Good morning, Mr. Lopez.
Good morning.
Can you just give me a few minutes before we get started?
Yeah, that's fine.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning George Lopez, 393-929. Today is Tuesday, December 3rd, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Osborn Correctional Institution. Please state your full name and DOC MA number for the record.
George Lopez, 393929.
This is a public hearing. Public access to this hearing is available via video live stream. Mr. Lopez, before we get started, I just want to make sure you're aware of your options today. Your parole officer is recommending that you engage into the TOP program. So we have two parts of the hearing, which is going over the charges, and then part two of the hearing is discussing the TOP program and your eligibility. So I just wanted to make you aware that you have the right to waive the first portion if you don't want to speak on your behalf regarding the charges, and we could go directly into part B of discussing TOP, or we can go through both parts 1 and 2. It's up to you.
I mean, we're gonna go over the charges. I mean, I feel like that'll be better. Explain my side.
Okay.
And so I can begin now.
Well, I'll tell you when.
Thank you.
This is a preliminary hearing which has 3 purposes under Connecticut law: to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. Please note that you have been referred by the Department of Correction for diversion for substance abuse programming and treatment. If by the end of this hearing I determine that you should be held in prison pending further proceedings, I will provide additional information about the diversion process. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Lopez, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You may hire your own attorney. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing, or would you like to proceed without counsel?
Proceed without.
You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your parole officers bring against you and the information underlying each charge. Charge 1, reporting. On November 15th, 2024, you were directed to report to the New Haven District Office after absconding from the App Foundation Inpatient Substance Abuse Program. You failed to report as directed. Charge 2, GPS. On November 8th, 2024, you cut off your GPS unit without your parole officer's permission, knowledge, and you stated that you threw it in the trash at your job. Charge 3, program participation. On November 13th, 2024, you were placed in the App Foundation Inpatient Substance Abuse Program. On November 14th, you called for a ride and absconded from the program. Charge 4, drugs. On November 8th, 2024, you began a crack cocaine binge. On November 12th, 2024, you voluntarily admitted to your parole officer that you had been using crack cocaine during the entire holiday weekend since Veterans Day. The state has filed the following exhibits. Exhibit A, Connecticut Conditions of Parole. Exhibit B, GPS Conditions. Exhibit C, Remand to Actual Custody Order. Exhibit D, Notice of Parole Violation. Exhibit E, Parole Violation. Exhibit F, Absconder Letter from App Foundation. Exhibit G, Letter from Ford Clinic indicating relapse. Exhibit H, Misconduct Positive Drug Screen. Exhibit I, Misconduct GPS Tamper and Removal. Exhibit J, Voluntary Admission Form. Mr. Lopez, did you receive the notice of parole violation, the parole violation report, and the other documents that I just marked for identification purposes? You should have received a parole package that had all the charges in it.
Yes.
Okay. Today we have no witnesses, and now it is your opportunity to respond to the parole charges against you. However, you may remain silent if you choose to do so. Would you like to respond at this time?
I'd like to respond.
Okay, go ahead.
All right. First off, I want to apologize for, messing up my opportunities to go home. And I know mainly this is due to my addiction. I just did a lot of time in prison, and I was doing good. I had a job, full-time job, training to be manager, working almost 50 hours a week. But I always slipped up and used drugs, and I know that's not right. And I'm trying to hopefully do this top program so I could get the help that I need and return home. And I know I let a lot of people down, including myself, and I'm just trying to get it right. I've done a lot of time, and I really feel like I need treatment more than anything, because clearly it's not registering after all this time I did. And I just want to go home and be a normal person in society and not have to live like this anymore. And once again, I apologize, and that's it. Thank you.
Thank you. So nothing further in regards to the charges such as reporting, GPS, program participation. I know you just admitted to using. Anything else regarding those charges in terms of the reporting, the GPS, or the program participation?
No comments.
Okay. Thank you. I'm going to take a moment before I announce my findings.
And there's one more thing I did turn myself in. I don't know if it shows that, but after I did the run from the App Foundation, I did turn myself in on that Monday. I know I had to get this over with if I wanted a fair shot.
Thank you.
Sorry about that.
That's okay. On charge one reporting, I make a no finding of probable cause as the state failed to provide sufficient evidence to prove that Mr. Lopez's actions meet the elements of this charge. On charge two, GPS, I make a no finding of probable cause as the state failed to provide sufficient evidence to prove that Mr. Lopez's actions meet the elements of this charge. On charge three, program participation, I make a finding of probable cause based on state's exhibits A, E, F, and G. On charge four, drugs, I make a finding of probable cause based on state's exhibits A, E, G, H, I, and J. I find that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait for your revocation hearing. The Department of Correction has recommended you for diversion from the revocation process for substance abuse programming and treatment. This is the top program. This means that if you wish to participate and apply, and I find that you meet certain eligibility criteria, I can continue your case while you are provided an opportunity to participate in substance abuse program and treatment while in a correctional facility. If you successfully complete the program and treatment provided, I will dismiss your case and order your parole reinstated. If you do not complete the program and treatment provided, the board will schedule you and convene a revocation hearing to determine if you violated the conditions of your parole. If so, the hearing examiner will make a recommendation regarding whether your parole should be revoked and what, if any, sanctions should be imposed. The decision to participate in the diversion program is voluntary. Do you understand the diversion process and wish to apply for diversion? Again, diversion is the top program.
Yes.
I will now announce my findings with respect to your eligibility. If I determine that you are eligible, I can accept your application and divert you from revocation. I have reviewed all relevant information and my findings are as follows. I find that you have no pending misdemeanor or felony charges. I find that your discharge date is more than 60 business days from the date of remand to actual custody order. I have found that there is evidence that you have identified substance abuse and treatment needs. I find that substance abuse is reasonably considered to be a motivating factor in your alleged failure to comply with the terms and conditions of parole. And I find that there is some evidence that you received or were provided with an opportunity to receive substance abuse programming and treatment during your period of parole supervision in the community. I have determined that you are eligible for diversion for substance abuse programming and treatment. Before I accept your application for diversion, I ask that you indicate whether you understand the following by answering yes or no. I understand that I will remain incarcerated while I receive programming and treatment, and that parole revocation proceedings may be delayed as a result.
Yes.
I understand that the dismissal of my case and reinstatement to active parole supervision is not guaranteed and is conditioned upon my successful completion of substance abuse programming and treatment.
Yes.
I understand that ultimately the Department of Correction will determine whether I have successfully completed the substance abuse programming and treatment provided.
Yes.
I understand that my participation in this program or in this process is completely voluntary.
Yes.
Your application for diversion is granted. You will be placed in a treatment or programming by DOC and diverted from revocation for no more than 60 business days. So this does not conclude your preliminary hearing. Okay?
Okay. So the date is the same. Just real quick, I seen somebody for the top program and they gave me two dates, which is January 24th and February 18th at the
It would be 60 days from the date you came back into custody, around that date. So you came back on November 18th. So February sounds about more appropriate.
February. Okay.
Yeah, so it's 60 days from the time that you came back into custody. And you came back in on November 18th.
Okay.
And then at that point, you would go back on, as long as you complete the program, you go back on active supervision.
So I wouldn't have to do like another hearing like this? Or
As long
no?
as you complete, nope. As long as you complete the program, you would then go right back out to parole.
All right.
Okay?
That's it. All right. Thank you so much.
You're all set. Thank you.
All right.
Thank you. Have a good day, ma'am.
You as well. Thank you.
Thank you.
Good morning.
Hi, how are you?
Good. We should have Mr. Moralez for 10:30 this morning.
Yeah, he's coming here. He's in a specialized unit, so they're escorting him over.
Okay, thank you.
He'll be coming by 10:30, but I think there might be something going on in the facility right now that might be stopping that. But it might be him as well.
Oh,
That-
okay.
It might be him getting escorted here.
Got it. Understood. Okay. Well, no worries. When he gets here, we'll just be waiting.
All right, thank you, ma'am.
Thank you. Good morning, Mr. Moralez.
Good morning.
We're gonna get started in just a couple minutes.
All right.
Good morning, Attorney Jones.
Oh, he's in. He's all set, ma'am, right? You guys can see each other?
Oh yeah, we're all set. Thank you.
All right.
I mean, it's still everywhere. But, past the initial kind of.
Attorney Jones, you should be able to unmute now.
Thank you. Good morning, P.O. Saunders. Good morning, Jonathan.
Good morning, Jones.
We'll get started. Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Jonathan Moralez, 395-889. Today is Tuesday, December 3rd, 2024. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office and MacDougall Correctional Institution. Please state your full name and DOC inmate number for the record.
Jonathan Moralez, 395-889.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit on behalf of Mr. Moralez.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Moralez, please raise your right hand. You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes, I swear.
Thank you. First, I will read your rights. Then we will review the parole violation charges that the state your parole officers bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, GPS. On October 1st, 2024, you signed your GPS monitoring agreement. By signing the GPS agreement, you acknowledge that you were to remain on GPS monitoring for a length of time determined by a parole officer and will not remove the GPS tracking device or strap from your ankle without prior permission from a parole officer. On October 1st, 2024, you cut off your GPS monitoring device from your ankle at 3:51 p.m. and abandoned it on the side of Broad Street in Bridgeport. Charge 2, residence. On October 1st, 2024, you were signed out of Maple Street halfway house at 2:40 p.m. to go to the emergency room at Bridgeport Hospital. At 3:35 p.m., staff called the emergency room and discovered you never arrived at the hospital and you failed to return back to the halfway house. Maple Street is your only parole-approved residence, and you have failed to reside at that residence since that time. You failed to contact your assigned parole officer and halfway house staff, which means your whereabouts were unknown until you were arrested by Waterbury Police Department on October 6, 2024. Charge 3, obedience to the law. On October 6, 2024, you were seen by employees at the Home Depot in Waterbury leaving with a drill you did not pay for. Waterbury PD saw you walking down the street, carrying the drill under your arm and determined you matched the suspect's description. Police attempted to stop you for questioning and you took off running from the police. Waterbury Police gave chase and you were apprehended and arrested. You were subsequently charged with 1 count of larceny fifth, 1 count of interfering with police, and possession of drug paraphernalia. The state has filed the following exhibits. Exhibit A, remand to custody. Exhibit B, parole violation report. Exhibit C, notice of parole violation. Exhibit D, notice of parole rights. Exhibit E, signed PCS conditions. Exhibit F, signed halfway house agreement. Exhibit G, GPS monitoring agreement. Exhibit H, GPS event history printout. Exhibit I, photos of GPS with cut strap at last known location. Exhibit J, Maple Street halfway house incident report. Exhibit K, Waterbury Police report. Exhibit L, revocation hearing summary from November 2022. And Exhibit M, revocation hearing summary from September 2024. The state has filed an addendum to Exhibit B, which states on October 30th, 2024, Mr. Moralez was found guilty of larceny fifth and was sentenced to 3 months jail. He was also sentenced to unconditional discharge for interfering with an officer. The charge of possession of drug paraphernalia was not laid. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted. Counsel?
Thank you. In regards to charge 2 under residence, we would just submit that there's insufficient evidence to support this charge, as there's no proof that my client moved out of the location. There's no proof that he intended to live anywhere else. And he maintains that though he did go to the Bridgeport Hospital on that day, he was waiting several hours to be seen. And he did leave that location and went to St. Mary's Hospital in Waterbury subsequent to that. So again, we would submit there's insufficient evidence to support that charge. In regards to charge 3, I believe the addendum is stated accurately. And I do calculate, I calculated his end of sentence date on the new sentence to be January 6th. However, my client does tell me that he received a time-stamped end of sentence paperwork from DOC staff that indicated his end of sentence to be December 30th.
I want to double check right now. It is, as of today, his estimated end of sentence is January 6, 2025.
Okay, thank you. Nothing further as to the charges.
Thank you. I'm going to take a moment before I announce my findings. In regards to charge 1 GPS, I make a finding based on state's exhibits B, E, G, and H. On charge 2 residence, I make a finding based on state's exhibits B, E, and J. And on charge 3, obedience to the law, I make a finding based off of Mr. Moralez's conviction, as well as state's exhibits B, E, and K. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background history. Counsel?
Thank you. My client is 29 years of age. He's single. He has no children. He does have a support system in Connecticut, and his grandmother, who's located in Norwich, as well as several other family members in that area. His sister is located in Waterbury. He was mostly raised in the foster care system in Connecticut. He attended the Long Lane School as a residential placement. And subsequent to that, was able to attend college at the University of Alabama. He does suffer from mental health issues, and that played a role in his having to return back to the state of Connecticut after spending some time in the state of Alabama where he was attending college. He does have a serious medical issue as well that affects his ability to use the bathroom, and that was part of the reason why he needed to be seen at the hospital following his placement in the halfway house. He does need medical care. He does have medication that he needs. He was discharged from DOC and placed in the halfway house without those medications, and therefore he was unable. It affected him medically, and he needed to be seen immediately at the hospital. He was in custody for approximately 2 years prior to being reinstated to parole, I believe, if you recall, on October 1st. And he was reinstated without a finding of probable cause in that situation. He was in the community, as you're aware, for just 5 days prior to being remanded on this new offense. As previously indicated, he'll complete that court sentence on January 6th of 25. He does need the support of parole to reintegrate back into society, but he certainly needs to be placed in a situation where he can be successful, and that does include focusing on his medical needs. So we are asking that he be re-paroled in line with his court sentence. He's asking me to be placed in a halfway house in the Norwich area, which I think would encompass Norwich, New London, Groton, that particular area. I do know that that's a difficult area to be placed in, and there's usually a significant wait period. So as a second choice, he's asking to be placed in the Waterbury jurisdiction. And then third, if that was not available, the New Haven jurisdiction. He is open to all employment opportunities and indicates that he has worked in the past at factory jobs, also in the restaurant industry. So we are asking again that he be re-paroled in line with his court sentence. Thank you.
Thank you. I'm just going to take a moment before I make my recommendation. Okay, Mr. Moralez, being that this is your fourth conviction since 2021, since your discharge in 2021, your third time evading parole supervision, to return to the halfway house, and you cut off your GPS approximately 1 hour after being discharged from DOC custody, I recommend revoke and re-parole on April 6, 2026, which is an approximate 18-month sanction with the following conditions: anger management, a general no contact with CK and JP, halfway house placement, and mental health treatment. My findings and recommendations will be forwarded to the board. You will receive an official written decision from the board, and your board review is scheduled for December 12th, 2024. Now, the board can lessen my recommended sanction, let my recommended sanction stand, or they can impose a sanction longer than what I have recommended, being that you are on parole supervision until May 2028. If the board does decide to impose a sanction longer than what I have recommended, then a supplemental hearing would be held. If a supplemental hearing would be held, then you would be notified of those reasons why the board would want a longer sanction, and then at that point you would reappear for that hearing. But we'll know on December 12th, 2024, which is the board's, when they make their final decision. Okay?
Jonathan, please contact me after that date and I can let you know what the board decided, okay?
Yeah.
Okay,
Thank you. This does conclude the revocation hearing.
thank you.
Take a seat, bud.
Your napkin or anything?
No.
Good morning.
Good morning.
Morning, my name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Frasier Harrison 151097. Today is Tuesday, December 3rd, 2024. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Cybulski Correctional Institution. Please state your full name and DOC inmate number for the record.
My name is Frasier Harrison, number 151097.
This is a public hearing. Public access to this hearing is available via video live stream. I noticed on your parole rights, you indicated that you didn't want this hearing. I just wanted to see where you stood today.
Well, I think I'm not sure. I believe I got like until March to discharge off of everything. And to be honest with you, I really think I need to just stay here and discharge and get everything over with, so I won't have to go out there and deal with the parole no more.
So you don't want your preliminary hearing today?
I really don't want it. I just want to know my discharge date and just stay here and do it.
Okay, so before I accept your waiver, I do have to make sure you know what you're waiving, and I will give you your discharge date in just 1 second. So you discharge on from special parole on March 26, 2025. March 26th, 2025. So by waiving today, you will be waiving your right to speak and be heard regarding the parole charges. You will also be waiving your right to have an attorney represent you today. You will also be waiving your right to review the evidence against you before this hearing. You're waiving the right to receive written notice of charges of violation, and you're waiving your right to submit any evidence in support of your case. And you're also waiving your right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand all these rights that you're waiving today?
Yes, I do.
Okay, so I accept your waiver. But be aware or be informed that I still have to review your case and make findings. But you'll get everything in writing. And as long as you're comfortable with continuing to waive, then this concludes the preliminary hearing.
All right.
So you're okay with waiving?
Yeah, so my date stays at March 26th?
Correct. Yep. Your end of sentence from special parole is March 26, 2025.
Okay, yeah, that's what I want to do.
Okay, you're all set.
All right, thank you.
Thank you.
Okay, back. I'm going